up. It's a public meeting, so everything is publicly available. And we're really grateful for everyone who's joined us, who's here at this dialogue, because it's obviously a very important conversation. My name is Lily Manoyam. I'm from SALO, the Southern African Liaison Office. I'm going to be handing over to my colleague, Busisiwe Ngumalo, who's going to be doing some opening remarks, and then the two of us are going to be chairing the meeting. So just after everyone has joined, connected to audio, and come from the waiting room, then we're going to get started. So thank you very much. And yeah, it looks like most people are connected. So over to you, Busisiwe. Thank you.
Thank you so much, Lily. Good morning to all those who have joined on the platform and those watching on the live stream. It's a pleasure to welcome you to this important dialogue on the Hate Crime and Hate Speech Act and a pathway forward for its implementation. In May of 2024, President Cyril Ramaphosa signed into law the Prevention and Combating of Hate Crimes and Hate Speech Act, which is a landmark piece of legislation that is aimed at protecting the most vulnerable communities, particularly the marginalized and LGBTI persons. The Act represents a significant step in addressing harmful attitudes and behaviors that have long threatened the safety and dignity of many in our society. Today's dialogue focuses on what happens next. Now that we have the legal framework in place, the real work begins. Changing societal attitudes that fuel hate speech, and hate crimes is very important. This is not just about enforcing the law, but also fostering a culture of inclusion, respect, and understanding that all individuals, regardless of their background, gender identity, or nationality. As we encourage this conversation today, let us remember Section 9 of the South African Constitution, especially subsections 3 and 4, which affirm that nobody may be unfairly discriminated against and remains a guiding principle in our efforts. Thank you for joining this critical discussion. This dialogue was made possible by the Constitutional Fund. We look forward to hearing your insights and working together to build a society that stands firm against hate in all forms. Thank you.
Thank you so much. So my name is Lily Manoyam. I'm from SALO, the Southern African Liaison Office. I'm going to be chairing the first part of this meeting. So just to let everybody know that first we're going to have our panelists presenting, as they are all very much experts in this area, and as Busisiwe has introduced. And also you are all very much welcome to introduce yourself in the chat function, where you can write, you can say your name and which organization you're representing, in order for us to get to know one another in the virtual room. And after the panelists have spoken, we're then going to be opening up to the section of the dialogue where everybody who is attending can also participate, can speak, and write in the chat. So you are welcome to prepare some questions and some input if you'd like, for when it's time for attendees to come in. So thank you so much. So I'm going to be introducing our first panelist. Moano Nemavidi is a law researcher at the Office of the Chief Justice. She's an emerging legal scholar in the areas of labor, environmental, and constitutional law, with experience litigating against the state in relation to xenophobia, housing, and informal trade. She brings a combination of litigation experience and research experience earned at the Constitutional and Thohoyandou High Court. So thank you so much, and over to you, Moano. Let me allow you to unmute and turn your video. Thank you.
All right then, good morning. I'd like to first thank the SALO community for having me, and I'd like to thank the attendees. It is not an easy task being placed at the mantle of a maiden voyage, in particular considering the gravity of the subject we're having today. But as an aside, I'd like to think it quite auspicious that we're having it on this date, in particular because today marks World Mental Health Day, which has close ties in some respects to the issue of hate speech and hate crime, but more closely to the subject now. Hate speech and hate crimes are quite pervasive issues, but they don't occur in a vacuum. This is to say, we are still living in a society where we are living with the vestiges of our colonial legacy, which has impacted how we see the LGBTQ community, how we interact within our race relations framework, how we deal with issues relating to religion and structures of dominance within that and in all those spheres. But something to keep in mind as we keep going with this dialogue is that there is an immense power in words to harm and to incite violence. And there's an old adage, which I think quite relevant to this, which is that thoughts become things. It's not just a metaphysical concept, but an actually proved concept. For those familiar with feminist thought, there is a hierarchy, or rather a triangle slash pyramid, that demonstrates how we can ascend from simple chauvinistic jokes said almost good-naturedly, that ascend eventually to issues like femicide and harmful practices like female genital mutilation. So it's quite easy to see that there is a correlation, or dare I say, a causality between harmful attitudes, beliefs, and opinions, as well as harm inflicted upon a particular group because of their individual characteristics, which may, as I've intimated before, include their sexual orientation, their health status in respect to HIV, their ethnic or cultural groups. So let's come back to the issue of hate speech and hate crimes not occurring in a vacuum. I think we're all quite familiar with the idea that our democracy is 30 years old, but we cannot have a 30-year-old democracy without speaking to its genesis. In more simpler terms, its birth. So in 1993, I would think that is when we had our conception of the notion and ideology of what it would mean to have a free and open society founded on values of human dignity, equality, and the advancement of human rights. And this came in the form of our interim constitution, which came to pass in 1993. This, as one would know, culminated in the 1996 constitution, which is now our final constitution, which speaks to issues of equal protection and benefit from and under the law through Section 9 of the Constitution, which prohibits discrimination on manifold grounds, which include but are not limited to your race, your sexuality, your HIV status. I've spoken to them just earlier on, but as a reminder, that is the genesis of where we find the constitutional authority to then have legislation such as PEPUDA, such as your hate speech and hate crime legislation dealing with these issues. So I think now, knowing that the Constitution has given us this kind of legislative framework to enable the establishment of equality courts that enable people to bring matters relating to hate speech and hate crimes in this manner, we would begin to see that we have been building on the trajectory that would allow us to finally enjoy equality amongst our peers and amongst societies, if I may put it that way, such that we no longer need to exist in a framework where anyone should be afraid to ensure that other people are not harmed by that free expression. So when we've brought together PEPUDA Section 9 of the Constitution, as well as the new Prevention and Combating of Hate Speech Act, we find that these are simply parallels trying to get to the same thing. In so saying, I don't wish to get into the nitty-gritties of section by section analysis, but to speak towards three core issues, which are: one, we are at a point in our democracy where we need to confront truths, not only as they relate to our own individual myopic groups, but as they relate to the marginalized individuals that are on the outskirts of our society and how to protect them. As we treat the least amongst them, that is how we can expect the shoe to fall on the other foot should we find ourselves similarly situated. The second leg is to spark conversation, because the more you shroud something in secrecy or to shove it away from the discourse, the more it thrives in secret. And then the third one is to foster self-introspection, because largely we do not wish to believe that we are part of the problem. And we may be part of the problem in seemingly non-harmful ways. Our silence is consent to the perpetuation of hate speech and hate crimes. Speaking to that, we still have the question of what constitutes hate speech and what constitutes hate crimes. Without going into the semantics of what this means, the answer is in the wording itself. It's a speech or actions intended to harm a particular protected group. Such protected groups would be those ones that I mentioned that are usually at the intersection of many discriminatory frameworks of thought. In any event, now that we have a definition for hate crime and our hate speech, loosely speaking, one would think about what has informed our present position now to regulate this matter. Some have argued that it's potentially over-regulated. We already have Pecuda. What more are we offering to the table? The Constitutional Court has had to grapple with Serelani, which occurred in the instances of religious utterances that seemed to denounce members of the LGBTQ community. But even in that, it wasn't quite clear, at least at the outset of the matter, how that would go. And I think what the legislature is trying to accomplish is to finally achieve certainty and clarity as to how we deal with this issue. And I think what the Act contributes now is to attempt to censure both the impact of hate speech as well as the underlying attitudes. Like I'd said earlier, it is not just an age-old saying that thoughts become things. It is those attitudes of discrimination that inform the actions that later manifest themselves in what has now been termed a hate crime, such as your assault, your corrective sexual assault as well, your vandalism of property. I think for some that are familiar with the late activist Yudi Smelane, who passed away after a corrective sexual assault, what is ostensibly taken to be one anyway, that there is a great need from now and in the past to deal with these issues in a manner that is actually effective. We've dealt with a legislative framework that has been unable thus far to provide people the necessary protection from these things. And it does so effectively by imposing penalties. These penalties range from fines and up to 3-year imprisonment in the case of first offenders in particular. But the question then arises, how do we make the balance between protecting free speech, legitimate bona fide speech, meant to solely express oneself, as that is also a protected right? And how do we then make sure that people don't fall within the net of this act? I would point towards some of the provisions within the act that deal with this, such as wherein the act requires that the Director of Public Prosecution personally sign off before prosecution is begun in respect of any individual alleged to have partaken in hate speech or hate crimes. I think that's one layer of protection so that we do not have the consequence of effectively silencing dissent. Any open and democratic society should be open to receiving different points of view, even when those points of view are not necessarily at par with what our own personal beliefs are. But the fine line is that in expressing our own personal beliefs, we're not meant to be pushing down or inciting to violence against individuals that are effectively equal equal recipients of the protections in the Constitution. Then the other thing is that with our equality courts and the various protections now in legislation, we have a combination now that enables the issues of hate speech and hate crime to be specifically targeted in an effort to create an open and democratic society, versus a situation where an individual is channeled towards the High Court and has to wait on the ordinary rules and processes to sort them out. And then the other protection is that when utterances are made in good faith and without an intent to harm, you would obviously not fall within the ambit of that space. But I think one other thing that needs to be considered is that with the enactment of this legislation, we are still not all the way there, which comes to the point that our convening here is about, which is where to from here. Ideally, we should be heading towards a point in our society where we are achieving restorative justice. And this ties into an earlier point where I mentioned that we have colonial legacy surrounding 3 main issues that I point out, which are issues of the LGBT community, race relations, and religion. Our form of society today, though we may think of it as being neutral, is not neutral. It is much to the exclusion of time-old beliefs that were honored about these particular 3 groups. The influence of colonialism permeates through them and hate crime. So in dealing with hate speech and hate crime, I would provoke the audience to think about how decolonization is one of the tools that we ought to be utilizing in our philosophy and in our language to free ourselves from issues of hate speech and hate crimes. This may be a call towards activism, a call towards spotlighting those issues that underlie beliefs that certain people in our society are less than others. This manifests itself also in contexts that we may think are unrelated, such as xenophobia. I think at a particular time, the discourse had moved not just to saying that people from other African countries are as human as we are, but to saying, why do we see particular groups as we do in the present date? Is it not in part linked to our history of oppression and segregation, even amongst ourselves, as ethnic groups, as racial groups, making sure that the structures of dominance keep us separate and unable to mobilize towards one common goal, which is that of a cohesive society founded on values that are now effectively our community mores. That is our Bill of Rights, our equality, our dignity. We need to be roping in ideologies that go beyond just the legislation. We need to be going towards a continuous progression towards decolonizing our country, as that is the crux of what it means to redress. In other words, not just to revamp an already Western notion of what it means to be equal and protected by the law. But this is to say, we can incorporate concepts such as Ubuntu through ensuring that we see the human nature of the next person. So to say, legislation alone cannot push us towards that threshold. It is through conversations, it is through confronting truths, it is through self-introspection at an individual level that we begin to have the ripple effect of unloosing the bounds of our past colonial oppression, and ensuring that in our society, we no longer just pay lip service, we no longer just put people in prison systems without having heed towards what the actual attitudes and mindsets are. Like I spoke earlier towards xenophobia, one would think about the influence of socioeconomic factors that create an us and them mentality from a perspective that the one group is taking what rightfully belongs to the other. But once we address those attitudes, only then and only then do I provoke the audience to think that we will be able to achieve the ideal of a society, or rather a South Africa, that truly belongs to us all, both in its underlying philosophy, being free from colonial bonds, and the material conditions enabling us to escape the crab bucket, as it's colloquially mentioned, of trying to fight one another in an effort to find ourselves at the top of the hierarchies of dominance and subjugation. I think that's the most that I can contribute at this point in time. And thank you to those listening.
Am I audible? It looks like the network signal is low.
You're audible.
Okay. All right. Well, we're going to so I'd like to introduce Keamogetswe Saipato, who is a Ford Foundation Global Fellowship alumni and a campaigner and researcher in the social justice sector. She's passionate about sharing and creating information and knowledge with those who are affected by how the political economy of the world and Southern Africa works, coupled with inspiration for establishing a means to tackle a patriarchal capitalism, which is an element of her activism. So we are very grateful to have you on our platform, and I'd like to hand over to you.
Morning, everyone, and thank you so much to the SALO community for inviting me to contribute to the space. And also thank you so much to my colleague who spoke before me, actually, sort of summing up some of the things that I was thinking about. The timing of this legislation is crucial as we continue to wrestle with the deeply entrenched problems of hate crimes and hate speech. While this act is a significant step forward, its true impact will only be determined by our collective effort as society. The real test lies not just in the implementation of the act, but a continued commitment to transforming the underlying attitudes that give rise to hatred. Someone whom I draw a lot of inspiration from shared with me something quite important. They shared with me that for the most part, decisions were made to ensure that we have a peaceful transformation that ushered in democracy in South Africa. So to a large extent, those decisions that were made to bring in peace meant that we were letting go of justice. So due to this, we have been facing different examples of what happens when peace is used as a band-aid on top of a complicated wound. This morning, we were brought together by one of the different examples of the complexities of the South African wound, which is the varying forms of hatred. My colleague before mentioned the point around restorative justice. So when we decided that we're going to have a particular democratic dispensation, and when we decided to go through the process of the Truth and Reconciliation Commission, we decided to push for peace. Therefore, then we did not create the conditions for full-on restorative justice. So many of the pain, the trauma, and the wounds that exist within the South African social fabric during apartheid and after apartheid still exist within the South African society today. And that pain and trauma breeds and creates the conditions for hatred. Not only do they breed and create the conditions for hatred, but as mentioned by my colleague beforehand, our colonial history has taught us to be and act in particular ways. The ways in which our colonial histories have taught us survival of the fittest, has taught us that looking a particular way, or being a particular race means that you're close to privilege and power. So come fast forward 1994 and fast forward to where we are in 2024, those psychological things that have been embedded in the psyche of a South African about power, privilege, race, and discrimination still exist today. This act represents an important step in providing protection to marginalized groups, particularly migrants and the LGBTQI persons, who have long been targets to hate speech and hate crimes in our society. It gives legal teeth to our constitutional principles of equality, human dignity, and freedom from violence. This act also mandates data collection on hate crimes and includes provisions for the police and the National Prosecuting Authority to be trained in handling these cases effectively. On paper, it is another vital intervention towards addressing systemic discrimination. However, legislation alone cannot transform society. The roots of hate crimes and hate speech run deep in our social fabric, and they're nurtured by systemic inequalities such as poverty, unemployment, and the long, long entrenched history of exclusion. Migrants and queer people, amongst others, have been targeted due to the normalization of harmful stereotypes and narratives. In these contexts, hate thrives, and we must recognize that the act is only a starting point to try to turn things around. Activists and comrades within the feminist and even the gender struggles will know that a lot of the work around the National Strategic Plan in relation to dealing with gender-based violence and femicide kind of has the same frameworks as this act. So it's a very clear inclination that on paper, we might have legal frameworks that give us protections, but what do they mean in real life? What kind of investment, what kind of energy, what kind of power is being put to bring the act to life beyond it being a piece of paper? While the act provides a legal framework, our focus should be on another harder task, which is collectively working on transforming societal attitudes. When we're working towards transforming societal attitudes, we can ask ourselves two key questions. How can we use this act as a catalyst for broader societal change, particularly in how we view and treat migrants and queer folks? And what strategies can we employ to challenge everyday xenophobia? But I would rather say it's not xenophobia, it is Afrophobia, and how homophobia in our communities, workplaces, and institutions can be challenged. We need to be thinking about addressing the root causes. The root causes of hate crimes and hate speech run deep. And as mentioned before, they are fueled by economic inequalities, misinformation, and long-standing prejudices. Some of the work that I've been doing with some folks around looking at the manifestations of political or toxic polarization in Southern Africa is around looking at how Afrophobia is a manifestation of toxic polarization. And some of the things that we're finding is that when we look at our political landscape, our politicians or political leaders use a concept called scapegoating to blame the economic inequalities that exist in South Africa on migrants or foreign nationals. This is not a phenomena that we only find in South Africa. It is not a phenomena that we only find in our region, but it is a phenomena that we find quite significantly on the African continent. And this is something that we also saw early on between, for example, Ghanaians and Nigerians. So the idea of the fact that African states, or if you look at South Africa itself, the organization of our economy, the organization of how we either able to provide services to citizens is in the balance of the fact that we inherited a particular kind of economic way of existing, which is, of course, I don't want to unpack a lot of that, but neoliberalism and capitalism. So when a new liberated or liberation leaders come in and they're needing to take over and they're needing to provide basic services for people, they're not able to do that because they're confronted with the fact that neoliberalism says that we're needing to be making money and giving or making sure that we're opening up particular services and resources to the masses without them being able to pay for it means that we're not going to be able to make profits. So when the masses then hold those in power accountable about where are our jobs, where are our homes, where is the land that we were promised, it is then blamed on the foreign national. So some of the things that we're saying and some of the things that we're wanting to kind of put forth as ways in which we can deal with this is we're needing to introduce nuance to the conversations that we're having. A lot of the discourses that have been taking place across the board, whether it is on social media, whether it is within our families, or whether it is just informally, has been stripped out of nuance. We're seeing human beings as singular identities, rather than seeing human beings as fully fledged, multidimensional entities. If we introduce nuance and complexities to our dialogues, we then give an opportunity to a diverse form of narrative shaping, and that pushes me to see a human being beyond their class, beyond their sexual orientation, and beyond their paper identity, but to start seeing commonalities between me and, for instance, Lily. Some of the things that we're suggesting are ways in which we could deal with this, or rather introduce a societal transformation in dealing with hate crimes, is introducing educational initiatives that promote understanding and empathy towards migrants and queer people. For example, implementing diversity and inclusion programs or even popular education programs in schools and workplaces. This is organizing cultural exchange events to foster understanding between different groups and different communities. Another suggestion is around community-based programs that foster integration and celebrate diversity. Another suggestion is around developing media strategies that counter harmful narratives and promote positive representation for marginalized people. So the suggestions are for us to go back into creating third spaces, creating civic spaces, going back into supporting community-based organizations, going back into supporting the churches and using the churches as a space in which we can create new opportunities for conversation and dialogue. What the negative camp has benefited from is making sure that a human being is just seen in a single identity. So I am a migrant and it ends there. And I'm then attacked because I am a migrant. So once we create spaces for dialogue, different narrative shaping, and spaces for us to understand each other, and spaces, most importantly, for us to introduce complexities and nuances, we can then create an opportunity for empathy and understanding. I wanted to round off with just a short call of action. I think what we're needing to be thinking of doing in relation to what happens next in terms of this act is collectively as civil society as a whole, we're needing to be contributing to supporting the robust implementation of the Act. And this can be holding government accountable in relation to the implementation. We need to be engaging in ongoing public education and challenging harmful ideologies at their core. So this sometimes means not shying away on asking questions or engaging positively on social media when we're seeing some negative comments or narratives stirring up. Some of the things that we should also be thinking of doing is creating less of safe spaces, but creating brave spaces and support networks for queer folks and migrant folks. And this could be not necessarily establishing new organizations and platforms, but this could be supporting organizations that are already within the diasporic network, organizations that are organizing young migrant youth, organizations that are supporting queer folks, small community-based organizations in the different areas that we're in. If we go in and we start supporting them and finding ways in which we can also bridge gaps with them, this could be a crucial step forward. And the last kind of idea is, how do we hold ourselves? The point that my colleague made prior around self-introspection. How do we hold ourselves accountable and the institutions around us accountable too, to making sure that we're dealing with the scourge of hate crimes and hate speech in the country? Thank you.
Thank you. Thank you very much. So I would now like to introduce our final speaker. And so just to let everybody know that you should start thinking about questions, because after Mr. John Jeffrey has spoken, we're going to be opening up the discussion to others. So just by way of introduction, Mr. John Jeffrey is our former Deputy Minister of Justice, where he served for 10 years. As Deputy Minister, he led the drive to pass the Prevention of the Hate Crimes and Hate Speech Bill, and he played a leading role in the government's work to advance LGBTQIA rights. In the 80s, as an anti-apartheid activist, he was detained in solitary confinement. Mr. John Jeffrey served for 30 years as a public representative in Parliament and government, and as someone who's been instrumental in the process of getting the Act signed into law. We're grateful to have you here and would very much like to hear from you regarding this topic. So over to you, and thank you.
Thanks very much, Lily, and good morning to everybody. I think I'm going to talk more about technical issues, and then also apologies if there's some renovation going on in my apartment block, which comes and goes. So that's why I've got earphones in, but hopefully it won't interrupt my input too much. The President assented to the Hate Crimes, Hate Speech Act on the 6th of May, 2024. But it's still got to come into effect. There's a provision that the President must set a date for it to come into effect. And that happens when everybody is ready to implement the Act. I just wanted to run through some of the provisions. One is the objects, section 2 of the Act, and it's to firstly give effect to the Republic's obligations regarding prejudice and intolerance as contemplated in international instruments. Number 2, provide for the prosecution of persons who commit the offences referred to in the Act, that's hate crimes and hate speech, and to provide for appropriate sentences. 3, to provide for the prevention of hate crime and hate speech. Provide for effective enforcement measures. I think I'm now on number 5, provide for the coordinated implementation, application, and administration of the Act. Number 6, combat the commission of hate crimes and hate speech in a coordinated manner. And lastly, gather and record data on hate crimes and hate speech. So you would see from that it is not just the criminalization of hate crimes and hate speech, but it's a lot broader than that. And in fact, the title of the bill is the Prevention and Combating of Hate Crimes and Hate Speech Act. Now, the Act then deals with 2 offenses: the offense of hate speech, the offense of a hate crime. I won't deal with those. I think those have been covered enough in the past. Then there's provision when it comes to sentencing for a victim impact statement to be laid in court. There's provision for that also to be, if the victim can't give a statement, that the prosecutor, if they can't, if there's no statement, the prosecutor must tell the court why there isn't one, and that the prosecutor may obtain an impact statement from amongst others, an organization or institution with expert knowledge or experience of the group to which the victim belongs or is perceived to belong. So it does widen the ambit of people who can testify in terms of the impact of the crime. Then it's basically the penalties or orders. And then to really come on to the sections that are the ones requiring implementation or work done. The first is that the National Commission of Police must set out or give instructions to the police, which must be complied with by all members of the SAPS who are tasked with the investigation of the alleged commission of hate crimes and hate speech. And in particular, they must deal with the reporting of alleged hate crime or hate speech dealt with by the police. This is now the manner in which you report a hate crime or hate speech, the manner in which they're investigated by police officials, and then also there must be training courses developed by the National Commissioner on these national instructions. They must include social context training in respect of hate crimes and hate speech, and provide and promote for the use of uniform norms, standards, and procedures, with a view to ensuring that as many police officials as possible are able to deal with hate crimes and hate speech in an appropriate, efficient, and sensitive manner. So that's the first thing that has to be done. The National Commissioner of Police must develop these instructions. Then the National Director of Public Prosecutions must come up with directives. Sorry, just trying to find the section. They must issue directives regarding all matters which are necessary for the enforcement of this act. And that would include the manner in which cases relating to hate crimes and hate speech are to be dealt with, including the circumstances in which a charge in respect of such an offence may be withdrawn or a prosecution stopped. So it's not just up to the prosecutor's discretion, it's the NDPP must set out directives as to when may you withdraw a charge or stop a prosecution. And then secondly, the leading of evidence indicating the presence of prejudice or intolerance towards the victim in order to secure a conviction for hate crime. And then also the collection and analysis of data. And they must also look at training of prosecutors, same as the police, training on these directives, social context training on hate crimes and hate speech, and provide for the use of uniform norms and standards. So there's things that the National Commission of Police, the National Director of Prosecutions have to do. Then the Minister of Justice must set out, prescribe, that's by regulation, information that must be collected and collated by the clerks of the courts, that's the district or the magistrates' courts and the registrars of the High Court, to enable effective monitoring, analysis, and trends and intervention. So there's a push to actually legislate how data gets collected so it can be analyzed. And that information on hate crimes and hate speech must be made available in a prescribed manner to Parliament, and then the chair of the Human Rights Commission, the chair of the Commission for Gender Equality, the chair for the Commission for the Promotion and Protection of the Rights of Cultural, Religious, and Linguistic Communities. Those are regulations the Minister of Justice must implement. There's a section on the prevention of hate crimes and hate speech, and that is aimed at the Human Rights Commission, the Commission for Gender Equality, and the Cultural Linguistics Commission have a duty to promote awareness of the prohibition against hate crimes and hate speech aimed at the prevention of these offences. And the Minister of Justice, or one of the ministers, one or more cabinet member designated by the President, must cause programs to be developed in order to conduct education and information campaigns to inform the public about these offences, to provide assistance and advice to people who want to lodge a complaint of a hate crime or hate speech, and to train public officials on the prohibition, prevention, and combating of hate crime and hate speech, which training must include social context training. And the South African Judicial Education Institute, which trains the magistrates and the judges, they must also implement training courses on social context training for judicial officers that are presiding in these cases. And then there's a specific section on the making of regulations. So what you've seen is the NDPP, the National Commissioner, have to do certain things. That's by way of directives and instructions. The Minister of Justice must issue regulations. There are processes for that they must be submitted to Parliament for approval 60 days prior to the publication in the Gazette. And if Parliament doesn't approve in the 60-day period, there's what's called a deemed approval, where it's deemed that Parliament has approved. And so that's basically the law. And then lastly, the Act comes into operation on a date fixed by the President by proclamation in the Gazette. And that date will be fixed when the regulations have been finalized, and hopefully also have the directions and instructions from the National Commission of Police and the NDPP having been done as well. I'm informed that the Department of Justice is in a process of developing the draft regulations. And there's a process of internal consultation with the National Commissioner, the NDPP, and stakeholders within the department, which they're hoping will end by the end of the year. And then draft regulations will be made publicly available to consult with interested parties. They're targeting the end of January 2024. And then the regulations are finalized. It can take 60 days for them to be finalized because of the 60 days that Parliament has. But if Parliament obviously approves the regulations in a shorter period of time, those regulations then would be in effect. So that's what the next step is, and what the next steps are. And hopefully we would see this act implemented in the first half. I mean, I think there's a target actually of the first quarter. I'm a bit more dubious of capacity, but hopefully in the first half of next year, the act will be in effect. Let me just say then, I think as far as civil society organizations are concerned, it requires participation, it requires monitoring, and it requires putting pressure on government. So I think there's a lot of work for civil society to do in terms of the effectiveness of this. Civil society can also engage with the Chapter 9s, the 3 Chapter 9s that are mentioned, the Human Rights Commission, the Commission on Gender Equality, and the Cultural Religious Communities Commission. So there's a lot for civil society to do. And really, as a last point, I mean, there was some opposition. There were 2 in Parliament when the bill was passed. There were sort of 2 groups that were really opposing the bill. There were some people opposing on a religious basis, which was, I think, specifically more aimed at LGBTI people. and the other section was people who may have been concerned about the fact that white right-wingers often get into trouble for saying racist things, but they also use the argument of free speech shouldn't be restricted. I've noticed with the American elections that is very much a refrain by, it seems, the American right wing of there must be free speech. There shouldn't be any restrictions on free speech. But it's very interesting that those same people want to shut down debate and discussions on issues that are taking place in Palestine. So there's quite an inherent or quite a substantial contradiction in, on the one hand, saying, no, there must be complete free speech, and then doing something completely different when it's to be applied. Let me leave it like that. Thank you.
Thank you so much, John Jeffrey, for your input. You've given us a way forward in terms of the legality of what happens in the next steps. And also to our other two speakers, you've also given us a lot of food for thought. We're now going to be heading over to the question and answer session of the section. So what you can do is that you can put up your hand. You can then briefly introduce yourself, and then you may ask your question directly. And also to the panelists, you also do have some time or room to also respond to each other of the inputs that you have made. So we're going to be going to the audience to just check if anyone would like to come in and ask a question. I'm just going to be checking the platform. Okay, you may. Okay, I don't see any questions in the platform. Just want to ask the panelists if there's any one of you. Okay, there's a question. It is from Paulette. So I'm just going to quickly ask you to unmute, introduce yourself, and then ask the question directly to any of the panelists. Or it can be a comment as well. Over to you, Paulette. Paulette, are you able to unmute? Lily, can you please assist Paulette to unmute so they can ask their question?
It should be.
Is it on? Okay. I've also asked them to unmute, but it seems like they're not winning. Okay, it's fine. We'll move on from Paulette while they work out the technical challenges. I don't see any other. Okay, there's a Paulette, I think, says they're trying to unmute, but it's not allowing. Paulette, if you're having technical difficulties, is it okay if you can try and type your question in the chat? And what I'll do is read it out loud and ask the speaker directly. So while Paulette is trying to figure out the technical difficulties, is there anybody else who would like to ask a question directly before we go back to the speakers? Okay, so I'm going to go back to the speakers and I'm going to go from the first speaker, second, and then last again. You may, I'm giving you guys a chance to respond to each other of the inputs that you have made. So we'll ask the first speaker to come in. Hi, am I audible?
I can hear you.
Okay,
Yeah.
great. All right, there's a hit from Lwazi. Lwazi will go first, and then we'll see if Paulette can come in, then we'll go to the speakers. Over to you.
Hello, Busi, hello, and thank you to everyone who has contributed towards this discussion. I found it very enlightening, to say the least. So I have two questions. The first question is first and foremost clarity from some of the legal experts in the room concerning when the president sets the date concerning promulgation or implementation of the Hate Crimes and Hate Speech Act. Are the set deadlines given towards government departments to be ready for the implementation of the Act? And how do we now broaden public education concerning ramifications stemming from the Act? Number two is, how do we now, even though we're facing major social challenges in terms of social attitudes towards historically marginalized communities, how do we now begin the process of unpacking or even unwinding the colonial nature, as previous speakers have mentioned, colonial nature of people's understanding of relations, especially amongst people within this country, especially in reference to the LGBTI community. And the third aspect is, how do we now hold even officials accountable beyond the usual routes around crimigeria when it comes to issues around hate speech. As you know, there are senior government officials during the campaign period which had highly problematic statements, especially relating to migrants, and we see some of the officials still agitating against migrant communities. How do we now push back, and how do we now build broader social network and agenda that will push back against these emerging trends within the South African community? And how do we now address this collectively? But yeah, fundamentally, I'd like to thank the speakers. I'm excited that such a legislation has been signed into law in South Africa. However, that key component on how we address the notions around social attitudes and in the realization of this new act will be very key. So thank you so much, Busi. Thank you to the panelists, and thank you to SALO for this.
Thank you very much, Lozi. I'm just going to quickly read the question that was asked by Paulette. They would struggle to unmute. I'm just going to read it out loud. So the question says, give me a second. What form of protection is offered to survivors of hate crimes and hate speech when they come forward to report and are required to also testify and confront perpetrators? So that's the first question. There's another question from Shoki. It says, what provisions exist in the Act to cover evolving forms of hate speech or hate crime, particularly in relation to social media and technological advances? So what I'll do is any of the panelists can answer the questions. I'll actually start with Gia. You can first answer any of the questions, and then I'll move on to John Jeffrey while the third speaker joins. Sorry.
Okay, cool, no problem. Just to say that I'm not a legal mind, I'm an activist like many other folks in the call. So the way I would approach to try to answer some of the questions is, I think what's critical for us to hold right now is we're at a moment in our country and even in our political landscape that things are actually changing. The kind of democracy that we brought in 1994 and the kind of electoral system that we've had gave us the past 30 years. We are now needing to collectively figure out, how do we go back to reconfiguring a society, a political landscape that works for the vast majority of South Africans. So this then means, for example, collectively within civil society, reinvigorating or even reconfiguring some of the different meeting spaces, dialogue spaces, organizing spaces that used to exist. And I think we need to kind of maybe move away from having this big public-facing dialogue event and go back to smaller dialogue events in communities, in townships, and even in rural settings. In that way, when we're trying to do that, we're fostering the opportunity to have conversations where people are at, but we're also fostering an opportunity to have conversations that are deeply authentic and are not kind of synthetically created by people having to come together at some conference venue and a hotel room. I think what's also critical for us to go through is that we are needing to sit together as South Africans as a whole, and we're needing to collectively figure out what kind of South Africa are we wanting going forward. So many of the atrocities and many of the questions around poverty, unemployment, and the myriad of problems that we're facing is an inherited kind of manifestation of the previous either political, economic dispensation that we've been operating in. So I'm trying to answer this question by actually saying that the answer lies in us collectively wanting to come to the table and contributing to shaping things. This notion of, no, it's not my issue, no, that organization is working on that issue, no, this is not my politic, has gotten us into a lack of nuance. It has gotten us to siloed ways of working. So we're needing to go back to, I know this is a little bit of a dirty conception because some folks are upset with it, but we needing to go back into really, really unpacking and bolstering an intersectional politic. So how do we deal with hate, but at the same time, how do we deal with the fact that hate stems from the fact that I am unemployed and I'm living under poverty, and there's no way for me to be able to put food on the table. So, and my political leader, who's supposed to be the representative who's creating the conditions for me to do so, says the reason why I'm in this position is a migrant. So we're needing to really, really get back to basics and create community spaces of conversation and dialogue. And we're also needing to go back to the opportunities of really reshaping narratives. So this is, are we engaging with our journalists? Are we engaging with the news? Are we writing articles in languages in which that open and expand conversation? Or are we writing things in a narrowed sense of operating? The last thing that I'm wanting to say is that we are going to need to move from a politic of advocacy to a politic of integration. So rather than me trying to convince you that my cause is the cause that we should be fighting for, it is more of me trying to work with you collaboratively for us to get collectively the things that we need, because the issues are human issues and not necessarily individual issues. Thank you.
Thank you so much for that. I'm going to hand over to Jeje to respond to some of the questions, and then we're going to go to the third speaker, and then we'll come back to round two. We'll start with you, Leanne, after that. So over to you, Jeje.
Okay, thanks. Look, just as far as Wazi's questions, there's no deadline for the implementation of legislation. It can take a while. It depends on the departments being ready to implement. As I've said, the target is actually implementation by March. I'm just adding my own realism and saying first half of the year, but they actually want to have it done earlier. But I think it's still important for civil society to be vigilant and to be asking when is this going to be implemented, so that it doesn't fall off the agenda, as it were. On the issue of criminal injuria, that offence was not repealed. That's a common law offence. So people can still be charged with criminal injuria. And there are some differences. Yeah, so that would continue. One would, though, expect that the statutory offence would be used more than criminal injuria, but it can still be used. Then, as far as, look, I see Paulette finally did manage to unmute themselves, but they have typed the question, so I don't want to take over Busi the chairing. But the protection offered to survivors, well, it would really apply to when they come forward to report and are required to testify or confront the perpetrators. I mean, that applies to really everybody who reports a crime and gives evidence in court of a crime. There is provision in the Sexual Offences Act that the survivor of rape or another sexual offence does not actually have to be in the courtroom where the accused is. And pre the greater advancements of the electronic era, there were there are special testifying rooms that have been established in many courts for the victims or the survivors to testify. There's also provision being made for intermediaries, and that has been expanded. I can't now offhand remember the requirement, but it's been expanded to having somebody suffering mentally from a mental health point of view. So I guess those could be used. We've now, when I was speaking about these rooms, we've now moved beyond that in terms of the fact that witnesses can give evidence virtually in court. So those are some of the things that can be done. But I think it's a very important point. The other aspect from Shoki was the provisions to cover evolving forms of hate speech or crimes, particularly in relation to social media and technological advances. Look, I don't know if the definition of hate speech or a hate crime, well, a crime is any crime that you commit, but of hate speech would change. It's basically requiring a person to intentionally publish, propagate, advocate, make available, or communicate anything to one or more persons in a manner that could reasonably be construed to, and then there's a requirements of being harmful or inciting harm and promoting or propagating hatred on one or more of the grounds. Just though technology is changing pretty fast. Communication is defined as including display, written, illustrated, visual, or other descriptive matter, utterance, representation or reference, or an electronic communication. And an electronic communication means a communication by means of data messages. I don't know. One would obviously just have to monitor how relevant those definitions remain, but the intention currently is to cover social media platforms. Look, I think there's a requirement of it being accessible to the public. So when it comes to if you distribute or make available communications, it's a requirement that they have to be accessible by any member of the public. So it doesn't include a private discussion, but obviously if somebody takes a screenshot of that private discussion and distributes it, then it is available to everybody. So we'll just have to monitor, I think, the development of technology on that. And then maybe Paulette's other question about secondary victimization. There could have been provision in the Act for, as there is with the Sexual Offences Act, for other support services. There's basically a reluctance to do that because what happens if the resources are not available? But I think the issue of preventing secondary victimization needs to be looked at. As I said, my proposals would be that the victim, if they're not able to testify in court emotionally, that they are able to testify virtually, and one would need to check whether they can make use of an assessor, and not an assessor, sorry, an intermediary. The way the intermediary works is that they take the question from the person who's asking it. It could be the prosecutor, it could be the defense lawyer. They put that question to the witness answers, and the intermediary gives that response to the court. So you don't have the defense lawyer, say, engaging the witness directly. Yeah, let me leave it like that. Thanks.
Thank you so much, JJ, for those answering the questions. Moana, we're going to give you a chance to respond to some of the questions that have been asked, and then after that, we're going to go to Leanne and then Mum Miriam. So Moana, if you may unmute and we may be able to respond.
All right, thank you. I think Mr. Jeffries has covered a lot of ground on what it means to actually deal with the issue of secondary victimization on a practical level. So I think my contribution would be going towards systemic issues that even when you have implemented all these legislative protections that aim to be practical, we still have systemic issues such as corruption and just mindsets surrounding issues of GBV, issues of inequality, issues of the LGBTQ community and race relations that transcend the ability of any single legislation to deal with. For instance, with a crime that is unfortunately all too common, your gender-based violence and your sexual assault, we still have issues of, despite national instructions to the contrary, police officials perpetuating and in some instances committing the offenses upon the victims that have come to report the offenses. So it's quite difficult to say then what needs to happen, because the back end of legislation is when it prohibits conduct, at the point at which you've transgressed, damage has already been done to the victim. So it looks to me that it's a solution that not only needs practical proposals by the legislature through acts and national instructions and the like, and community mobilization to conscientize people at a grassroots level as to how the issues manifest. But to some extent, at a certain level, you can understand that the horse may have already bolted. So it speaks to the need to begin earlier and earlier interventions in the minds of children, in particular groups that are statistically seen to be more likely to be affected by these issues. And part of that is issues of spatial inequality. Earlier on, I think the discussion also centered on how our current system of, how shall I say it, let's say capitalism, to put it bluntly, has made it difficult to foster community-based thinking. But we need to find ways, even in our education system, even in our advocacy, in our mobilization, to center community at the heart of how we educate and inform and impart new attitudes to ensure that the legislation, while it might be there, is not putting a band-aid on a sinking ship, so to speak. So at that level, I think it's a call to start individually doing the work, to not shy away from the conversation, to point out hate speech and hate crime when it occurs, in particular in a context where we're now in a social media era where everyone can say anything at any time and spread a message relatively fast. We need to not allow those attitudes to spread without having some sort of censure. There is a great power in numbers, and when you have 100 people, it simply demonstrates that one person 100 times over made the decision to say this far and no further. And when that has its compound effect, it does a lot more than we can see at an individual level. But great change starts with small actions, and those small actions start from ourselves.
Thank you so much, Moana, for that. We're going to move on to Leanne and then Mum Miriam. Leanne, over to you.
Good morning, everyone, and thank you for the the space. I guess just to be a bit practical here, in terms of community-based organizations, civil society organizations, what role can we play in terms of assisting victims? And I guess also looking at how can we help in gathering evidence, kind of thing to do it that is not done in a way that can get it thrown out of court. And maybe that's a webinar on its own. The other question was just around crimes that are committed before the act is implemented. Is it only crimes that are committed after the date that can be laid, or can crimes prior to the implementation still be used in reporting? Is one other question I have. And then the other one, in terms of asylum seekers or refugees who haven't got asylum status, and are victims of hate speech or hate crime, what remedy do they have within the legal system, particularly around hate crimes and hate speech, Bill? Thank you.
Thank you, Leanne. Ma'am Miriam, over to you.
Thank you, and thanks to all the those that have presented. This has been a very educative session, and I just want to thank all of them and SALO for the platform. And I truly believe that a lot still has to be done, especially within, our organization and, community-based organizations and civil society. And like one of the speakers said, that, legislation is something else, but what happens on the ground, the practices, the interpretation of the very same protective laws, it's something else. I mean, we, on a daily basis, we also experience some of the hate speeches and hate crimes. We have people that we know that have followed the law and go to the police stations, and often they're being even discouraged to report some of the cases. So I'm happy to hear that there is training for the police and everyone, but how soon are some of these things done? What are the timeframes? Because as it has been indicated, the marginalized groups and many other people are the victims on a daily basis. But I just wanted to thank you and to say there must be broader discussions on this matter. More platforms should be created to share this critical information that was shared in this platform. Thank you very much.
Thank you so much, Ma'am Miriam, to that. I'm going to quickly give Kia a chance before they leave to respond, and then we're going to go to John Jeffrey and then Moana. So, Kia, if you want to quickly step in.
I don't have anything actually to say other than thank you for the opportunity to contribute to the space. And I'm really looking forward maybe to having opportunities to being in these kinds of dialogue. I think it's important for us to find ways in which how we can expand legislation into real life examples so that it's tangible for the folks that need this protection. Thank you so much.
Thank you. JJ?
Thanks. Look, just as far as the first question, role of civil society organizations, I think that, let me put it this way, quite a lot of work is done by civil society organizations in supporting survivors of sexual offenses. So there's the precedent already there that can be done. And I think that civil society organizations should look at what they can do in terms of giving support. Yes, we've had situations where somebody has been charged with a hate crime murder, and of a lesbian or gay person, and people from civil society and the community will protest outside the court. So that has been happening already. But I think the issue was specifically more support for survivors. And I think that's something I'd throw back to civil society. Obviously, these appearances are going and prosecutions are going to take place near where they happened. So the first appearance will be in the district court, which covers the area where the crime was committed. If it goes to the regional court, it will be then the regional court. It might be further away, but it will still be the local regional court, as it were, or high court would then be generally in a provincial capital. The issue of a crime in South African law, a crime has to exist at the time it was committed. So you can't be prosecuted for crimes that were committed before that crime existed, that legally existed. So any hate speech committed, alleged hate speech committed, would have to be up until this comes into effect, would have to be by way of crimen injuria. And then on the issue of asylum seekers, look, we did, when the bill was in Parliament, expand that ground to be, and the grounds are basically what you can't, you can't use, or you have to prove that this was used for hate speech. And the ground is nationality, migrant, refugee, or asylum seeker status. So it doesn't matter. Well, if the and this is now, if you are in those categories, you are claiming it's hate speech because you are a asylum seeker, or you're waiting for your outcome, or your outcome came and it was denied, but now you're waiting for an appeal. So it would cover all of that. So I don't know if that really answers that question. On the issue of the timeframes for the implementation of the training, I think that's a very good question that needs to be asked. It should be asked when the department comes to Parliament to speak about the implementation of this act. And both, it's a question that obviously should then be asked to the three bodies responsible: the National Commissioner for the Police, the National Director of Prosecutions, and the South African Judicial Education Institute. So each of them should be asked, okay, now what are you doing about this? When is it going to be implemented? Thanks.
Thank you so much for that. I just want to check if there are any, this is the final round of questions. If anyone would like to ask a question or give a quick input. Yes, there is one. So I'm just going to read it out loud, and then I'm going to give back to the speakers to answer this question and also do your parting shots. Then I'll hand over to my colleague Lwazi to do some closing remarks. So the question is from Noluvuya, and it says, to organizations such as Tears, Sweat, and POA and others present today, they just want to find out their challenges related to offering counseling to survivors of sexual violence. And from afar, there seems to be challenges with regards to the systems already in place that fail to effectively provide counseling to those who have been affected. For examples, programs that are often conducted by counselors who are not properly trained to deal with matters affecting survivors of corrective of the LGBTI community. So any of the other JJ or Moana can answer this question directly, and then in your response, you may also do your parting shots before we head over to closing. So I'll go back to Francois. Moana, over to you, and then to JJ.
All right, thank you. Just to go backwards, I don't have much exposure to that space, unfortunately. So I can't speak to the challenges that are faced in that environment, but I do echo the point that capacitation is quite a big challenge, especially when it comes to dealing with issues of diversity, equity, and inclusion, in particular with regards to the LGBTI community, which ties into the question of how can community-based organizations tighten up efforts in a way, so to speak. I would suggest that we don't forget that a collective, when it is well organized, can push for meaningful change. If we draw from our past examples, such as the Treatment Action Campaign, which effectively radicalized the future of HIV/AIDS treatment and advocacy through just mobilizing in community spaces and letting the snowball effect grow the numbers of people that are involved. So in that sense, it's just a clarion call to say, let's not look down on the power of organizing. What civil society organizations, NGOs, the like, are doing in that space is extraordinary. And to keep going with that radical work is what allows us to consistently push the bounds of what the legislation is offering and ask for more, because it is still our entitlement to ask and ask and ask until we are answered and we can effectively see the vision of a transformed society that reflects our shared values. I'll also just point towards the need to just one-on-one. We treat it as an individual mission to conscientize in whatever spaces we may be. It's tireless and sometimes thankless work, but that work is what enables us to enjoy the gains that we've made so far. So while I don't have concretized suggestions, I think my parting remarks would be to not look down upon the power of just mobilization on a one-to-one basis. I can point towards successful examples like Abahlali Basemjondolo, which started as a small movement of shack dwellers that said we deserve housing, we deserve to be recognized in society, and to be able to live in dignity, even though we've been overlooked for X amount of years. And through that, it grew until it was able to partnership with other civil society organizations such as the Socioeconomic Rights Institute. And it's through also partnership, which is my second point, that we're able to maximize our gains, pull our resources to make up for the deficits in the funding space. It lessens our susceptibility to the impact of funding lessening just globally and the change in priorities of funders across the world. So through partnership and through maximizing our community mobilization, I think there's a lot that we can do to change thoughts and attitudes that in turn inform policy and inform legislation and inform research, such that we'll be able to use the data we collect to inform our research, inform our legislation, and also deal with the practical realities and difficulties of implementing in legislation. I'd like to thank SALO for the invitation and everyone attending for lending an ear. That's me.
Thank you very much. JJ?
Thanks. Look, on the issue in the chat of where's it gone? Of the other organizations working in the survivors of sexual violence sector. I think it's also a very useful question. I would think that the difference, though, with hate crimes and hate speech is, and maybe I'm naive on this, but there are going to be fewer of them. Whereas with sexual offenses, basically every court has them on a regular basis. This provision in the regulations for the Sexual Offences Act for psychosocial services. So it's something that government has to ensure is happening in those courts that are designated as sexual offences courts. even if they're doing it together with civil society. But I think it's for civil society. I mean, the reference is made by Noluvuyo to councillors not trained in matters affecting the LGBTI community. Yes, that is obviously going to be a problem. You need a councillor who knows how to counsel people from those communities. And there's many communities in the LGBTI QI plus sector, and I'm not a psychologist, but I would have thought that counseling a gay or lesbian person may be different, or you may need different knowledge or skills if you're going to be counseling a intersex person or a transgender person. Similarly, if you are going to be, you may be skilled in counseling LGBTI people, but you may not have much familiarity in terms of, or skills or experience in terms of counseling migrants, for example. So I think it's things that it's probably easier for civil society to look at, okay, when this happens, what can we do? Then just in closing, look, I'd also want to thank SALO for organizing this event. I've been very pleased with the attendance and the questions that have been asked. The success of the implementation of this act is going to depend on civil society. So I would urge civil society to continue to be vigilant. Somebody, I can't now remember who it was, that spoke about, no, we can ask. Well, maybe because I've now moved from government to civil society, I would say, well, yeah, in some cases it's fine to ask, but in other cases you may have to demand. And that is also what you're entitled to as well, what we're all entitled to. But thanks very much to SALO. Maybe one other point, there was a hate crimes working group which had existed for a long time. After the passing of the bill, I'm not sure what has happened to them, but you may want to, or some of the civil society organizations may want to explore what is happening with that. Yeah, thanks very much. And thanks for all the questions and everybody who attended.
Thank you so much. I'll now be handing over to my colleague Lwazi, who will do some closing remarks. Lwazi, over to you.
Thank you so much, Busi, and thank you to the panelists today for illuminating us concerning the hate crimes and hate speech bill, along with reminding us about the necessity for an intersectionality in our approach towards dealing with our common challenges, not only as people within the civil society sector, but people who are driven by the passion around human rights, the protection and upliftment, and also upholding of human rights within South Africa. Part and parcel of this is the elevation and protection, along with the expansion of the South African Constitution, to embolden and to encompass everyone who was historically marginalized and was impacted by the historic legacy of settler colonialism and apartheid, in order for us to elevate and create a better community and society, for us to create a better Africa and a better world going forward. We as SALO commit ourselves to continue having these discussions and creating broader networks that unite people around common values and a common theme around human rights, democracy, and the protection of those historically marginalized. We would like to thank the Constitutionalism Fund for helping us in exploring these discussions in order for us to broaden our networks, to understand what legislation is happening within our country and continent, and to understand the impacts and the role that we have to play in order for us to generate some form of national consensus on the challenges that we may face. We know the passing of the hate crimes and hate speech bill is not the be all and end all. However, we can take proactive steps to ensure not only the promulgation and also implementation of this bill, but also ensuring government adds budgets towards the pieces of legislation that need to be implemented. And part and parcel is for us to continue agitating. continue mobilizing, and continue having these discussions in order for us to realize the South Africa region, South Africa, the SADC, and the African continent that we want. That is inclusive of all people that belong in this continent and who owe their lineage towards this continent. And doing so, we'll be able to create a better world and a better humanity. So on behalf of SALO, I'd like to thank each and every single one of you for coming to this dialogue and for participating and for engaging. We promise you more of these dialogues in the weeks to come. Thank you and enjoy your afternoon.